It's time to remove that personal representative. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover the State Court Administrative Form PC 604, Petition for Removal of Personal Representative and the Appointment of a Successor. With all of these State Court Administrative Forms, they're easy to find on Google, or you're welcome to call my office. We'd be happy to give you one. This form is used when the personal representative needs to be removed for a variety of reasons. It could be the death of or incapacity of the personal representative. It could be that they have failed to perform their responsibilities, or they've resigned and there's a need for the appointment of a successor personal representative. This form, PC 604, is governed by the statutes and court rules as referenced in the bottom right corner of this particular court pleading. With all of these state court administrative forms, it's really nice. They've identified the statutes and court rules that govern this particular pleading. Now let's cover them. So MCL 700.1309 is the form or the statute that identifies the use of a special fiduciary. When a personal representative may have failed to perform their role, 700.1309 identifies when a special personal representative can be appointed by the court, either by petition or on its own motion. So this form is used when the court is aware that something's gone awry and there's a need for a special personal representative to be appointed to step in and intervene. The next statute we're going to cover is MCL 700.3609. This statute identifies the basis because the personal representative has either died or is now disabled, and that upon the personal representative's death, of course, their legal authority terminates, and there will be a need for a successor personal representative to be appointed. MCL 700.3610 is the basis for the voluntary resignation of a personal representative. The personal representative no longer wants to perform the role, or for whatever reason says, I've had enough, and signs a resignation. In addition, after 1 year from the sworn closing statement, their powers terminate by virtue of the lapse of time. Automatically under 700.3610, the personal representative, their role and their powers terminate after the 1 year. Now, the other statute that's referenced here is 700.3611, and it talks about the termination of a personal representative for cause and the procedure when a family member feels aggrieved by the role that the personal representative is performing, and there's a desire to ask the court to remove the personal representative because that personal representative is not performing their role correctly. We're going to go through the basis for doing so and how you file this petition to give notice, and then the basis that the court, or the elements that the court will look for reasons that the court would remove the personal representative and appoint a successor personal representative, which may be a family member, it may be somebody that's identified in the will as the successor personal representative, or it could be a neutral party that the court appoints. So let's work our way through this particular petition. The top left corner, it identifies the county in which the probate is being handled. On the top right corner, it asks for the file number. Pretty easy. You pull that off of the court pleadings that have already been filed. And then, of course, this is the petition as identified in the rectangle for the removal of a personal representative. You identify the estate name there. And in section 1 here, you identify who you are that's filing the petition. Subsection 2 identifies that somebody had been appointed personal representative of the estate and that they've either died or is now under disability in the form of a conservatorship. So maybe the personal representative has been injured or has gotten ill or has a disability or dementia and is in need of a conservator, and that their authority is now suspended by that statute that I referenced earlier. Death or disability through conservatorship would cause the personal representative's powers to be ended, and in this case, a need for a successor personal representative. Subsection 3 says that the personal representative has resigned. So this would be the basis in that statute that says if a personal representative tenders a resignation, they say, I don't want to do this anymore, and it's attached to the petition or already filed with the court, that would be the basis for the petition. Subsection 4 speaks about the request of a person trying to remove a personal representative. So this would be an adversarial style. The personal representative wants to remain as personal representative, and a family member is asking, or maybe it's not a family member, but an interested party is asking for the removal of the personal representative. That's where subsection 4 comes into play. And they're asking to either remove them as personal representative or special personal representative of the estate. The second box, subsection A, would be clicked if you identify that removal is in the best interest of the estate. So usually you're going to click that box. B says the person who sought appointment of personal representative intentionally misrepresented material facts. So this occurs when an estate is open and material facts were misstated on the original paperwork. Subsection C speaks of the personal representative has either disregarded a court order, is incapable of fulfilling and discharging their duties as personal representative, has mismanaged assets, meaning mishandled financial affairs relating to the estate, or the catch-all, has failed to perform a duty pertaining to office, meaning they just failed to follow the requisite statutory obligations as the personal representative. This next section gives you a room to identify some of the facts that form the basis of your request for the removal. Now, even though there are 2 lines listed here, you can attach extensive additional narrative as well as material to the petition to show the court the basis and need for the removal of that personal representative. Subsection 5 identifies that the interested parties, whether the interested parties are consistent from earlier petitions or documents that have been filed, or now whether they have changed. You have to keep updating the court to the interested parties' addresses, so if people have moved around, you can update that information there. Subsection 6 says that you're asking the court that it is necessary that a successor or new personal representative be appointed to allow for the administration of the probate estate to continue. Now let's look at the back side of the document. Here's where you're making your request of the court. You are identifying, here judge, here court, here's what I'm asking you to do. I request that either A, this person who's currently the personal representative be removed as personal representative, and that all of the property under the control of the personal representative be turned over to the successor. B, that person be directed to file a final account. C, the identification of the person you're asking to get appointed, either special or successor personal representative. So even though there are 3 check boxes, all 3 can be checked, or one or the others could be checked. But generally, you're going to check all 3. If you believe that the personal representative has failed to carry out their duties, then you're probably going to want them to do an accounting to the court, and you're going to be asking for a successor personal representative to be appointed. This next section is the penalty of perjury clause. It exists with all probate pleadings, and it is an identification that you are declaring to the court that under the penalties of perjury, the information contained is true to the best of your information, knowledge, and belief. The next section is really intuitive to fill out. It identifies if there's an attorney and the petitioner who's filing the petition, their information is included here, and it's signed. And this is the document that you then, after it's fully completed, gets filed with the court, and it will get scheduled for hearing before the probate judge, and then it has to be served. It has to be served upon all of the interested parties of the estate to allow people to object to the petition that may be filed. And if there is an objection or a contest, that matter can be resolved at a court hearing down the road. Now, if there's no objection, usually these petitions move pretty smoothly unless the court has a particular concern about the nature and basis of the petition that has been filed. But ultimately, it's up to the judge to make that determination. At the Probate Pro, we're passionate about probate-related issues. If you have questions about a petition to remove a personal representative, the affairs and how a personal representative is handling a probate estate, or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.